Welcome to TDS, the Trial Defense Service. I am Captain Barbara Carrain, and I will give you an overview of the Enlisted Administrative Separation, or chapter process. At the end of this presentation, you will have the opportunity to speak with an attorney from TDS. Attorneys assigned to the Trial Defense Service are not in any way affiliated with your chain of command or any commander on installations where they are located. Their mission is to advise you, the soldier, on what they believe to be in your best personal and professional interest, without regard to what your chain of command may want. Their service is provided by the Army at no cost to you. You may also hire a civilian attorney at your own expense. You or your escort must have your original separation packet, as well as a complete copy for you to review prior to meeting with an attorney. That is your right under Army Regulations 635-200, the regulation that covers involuntary separations. You must also have completed your mental and physical evaluations. If you have not completed the mental and physical evaluations, please notify the paralegal when called. You must also have been notified in writing that your command wants to involuntarily separate you. Please look at your packet to see if your commander signed the memorandum notifying you that the administrative separation process has begun. If it is not signed, please notify the paralegal. Separations under Army Regulations 635-200 are administrative in nature. They are not considered punishment. It is your command's way of forcing you to leave the service prior to the end of your current enlistment. There are many reasons that a soldier might be involuntarily separated or chaptered. I won't discuss every possible chapter with you. You should also know that you will, if administratively separated, usually receive one of three characterizations of service: honorable, general under honorable conditions, or other than honorable. An honorable discharge is appropriate when the quality of your service generally has met the standards of acceptable conduct and performance of duty for Army personnel, or is otherwise so meritorious that any other characterization would be clearly inappropriate. A soldier separated with an honorable discharge will be entitled to all Army, Veterans Administration, or VA, and state benefits. This specifically includes GI Bill benefits and educational assistance from the VA. A general discharge is a separation from the Army under honorable conditions. These separations go to soldiers who have satisfactory military records, but not service that is sufficiently meritorious to deserve an honorable discharge. A soldier separated with a general discharge will be entitled to substantially all the benefits that may be given by the Army, the VA, and state law. However, a soldier separated with a general discharge is not entitled to benefits from the GI Bill or educational assistance from the VA. An other than honorable, or OTH, discharge is appropriate when the reason for separation is based upon a pattern of behavior that constitutes a significant departure from the conduct expected of soldiers. A soldier separated with an OTH discharge will be deprived of substantially all benefits that may be given by the Army, the VA, and state law. This separation can have devastating impacts in both long and short term. This discharge is the most severe you can receive in an administrative separation. Don't confuse an OTH discharge with punitive discharges, including a bad conduct discharge and a dishonorable discharge, which are only issued by a court-martial. So what rights do you have if you want to stay in the Army or obtain a better discharge? It depends on whether you are entitled to an administrative separation board or only have the right to respond directly to your chain of command in person or in writing. Soldiers are entitled to a separation board under two circumstances. The soldier has 6 years or more of combined active or reserve service, or the command recommends that the soldier being separated receive an OTH discharge. First, let's discuss a separation board. A separation board is one composed of 3 commissioned officers, or 2 commissioned officers and a senior non-commissioned officer. They determine whether or not a factual basis for the separation exists. If they find a basis, then they determine whether or not you should be separated from the Army. If they find you should be separated, then they determine the characterization of your service. If the command wants to separate you with a general discharge and you have less than 6 years of service, then you are not entitled to a board. If you are entitled to a board, then you also have some additional decisions to make today. You have to decide whether or not you want administrative separation board. If you are satisfied with the potential separation from the service, as well as the proposed characterization of service, or you wish to leave the service as quickly as possible, you may want to waive the board. If you decide that you want a board, then you may waive your personal appearance before the board. If you elect to do this, the board will still meet and make the findings they are required to make, but you will not be present, although your attorney may be. If you decide you want a board and want to personally appear before the board, you may waive representation by an attorney during the board itself. All of these options have consequences you may not be aware of, so please discuss them with the attorney before electing any of them. If you decide to waive the board, you can make your waiver conditional in order to receive a higher level of discharge. For example, if your command wants to separate you with an OTH discharge, you can conditionally waive your right to your board, provided that your command separates you with an honorable or general discharge. If you decide to waive the board, you can still submit statements to your command. You can make a written personal statement indicating what you think is appropriate in this situation. You can also include other evidence, such as statements of good duty performance from coworkers, awards, certificates of appreciation, and letters from family or friends. If you have any questions about what you should present, please discuss them with the attorney who will be available to see you soon. If you are not entitled to a board, then you may submit evidence you want your chain of command to consider before they make a decision on your separation. You can make a personal statement indicating what you think is appropriate under the circumstances, and you can include other evidence such as statements of good duty performance from coworkers, awards, certificates of appreciation, and letters from family and friends. If you have any questions about what you should present, please discuss them with the attorney who will be available to see you soon. There are a few other things to know before we conclude. First, you are entitled to a copy of the complete packet. You should have a copy now. However, your current copy does not have the memos in which your chain of command will make recommendations or the order of the separation authority that will direct separation. Please make sure you obtain these documents prior to your separation. Second, if you are entitled to a board and you have asked for the board, please stay in contact with your attorney. A board is not as formal as a court proceeding, but you will still need to prepare thoroughly with your attorney. Also, if you voluntarily absent yourself from the Army or go AWOL, the command may be able to proceed with the separation in your absence. Do not leave until the separation process is complete and you fully out-process the Army. Absence without leave is a crime, and the command can choose to prosecute you at a court-martial when they regain custody of you. Third, if you have unconditionally waived any of your rights, you may withdraw that waiver at any time before the separation authority orders, directs, or approves your separation. Fourth, if you have made an unrestricted report of a sexual assault, please let your TDS paralegal or attorney know about that fact during your interview. Fifth, you have a right to appeal this action to the Army Discharge Review Board or the Army Board for the Correction of Military Records. If you think you might want to appeal, please be sure to get your complete separation packet before you are discharged. Please note that there is no such thing as an automatic upgrade of your discharge. Your characterization of discharge will remain in effect unless and until the Army Discharge Review Board changes it. Sixth, your time in the Army may be coming to an end, but it is not over yet. If you get into trouble now, you can still be punished under the UCMJ. Everyone being processed for separation must have the opportunity to speak with the Trial Defense Service attorney. It is required by the regulation. Do not leave until you have had that opportunity. The Veterans Administration and Army Transition Assistance Offices also have information on benefits upon separation. Please consult them as the information may help you understand what specific benefits you may receive should you ultimately be separated. Thank you for your attention.